Hello friends, myself Mohit and I am going to dictate you Steno legal matter. Please subscribe my channel and press the bell icon for more dictations. So be ready for the dictation. 5, 4, 3, 2, 1, start. By responding the aforesaid judgment, argument Shri N.K. Patel, learned senior advocate, has said that the provision of Order 1, Rule 10 of CPC is not available to the appellant after withdrawing the applications filed under Order 22, Rule 4, 9 and 11 of CPC and also under Section 5 of Limitation Act regarding bringing the legal representatives of deceased respondent on record. Stop. The appellant could not be permitted to circumvent the provision of Order 22, Rule 4, 9 and 11 of CPC by invoking the provision of Order 1, Rule 10 of CPC. Stop. The abatement of the appeal is automatic process. Stop. If the legal representatives of the deceased parties are not brought on record within the prescribed period, then the abatement is occurred, which could not be set aside without any sufficient cause for condoning the delay, and such applications have been disposed of by this court considering the request of the appellant to withdraw the same. Stop. He also placed his reliance on some reported cases and prayed for dismissal of this. It is basic proposition of law that Order 22, Rule 10 of CPC is applicable to bring the person on record with leave of the court who acquires the rights in the disputed property during pendency of the suit by assignment, creation or devolution. Such person may come or bring on record with leave of the court at the place of such party of the suit from whom he acquired such rights in the aforesaid manners. Stop. But in any case, such provision and the provision of Order 1, Rule 10 of CPC could not be invoked to defeat the provision of Order. Stop. On other words, by defeating the provisions of Order 22, Rule 4, 9 and 11 of CPC, the person like appellant could not be permitted to circumvent such provision by invoking the provision of Order 22, Rule 10 read with Order 1, Rule 10 of CPC. Stop. In this proceeding, we have already noted that the applications for substitution after setting aside abatement was made and rejected, as a result whereof the suit was bound to abate in respect of the deceased persons. Stop. The court did not find any sufficient reason for setting aside the abatement caused by the deaths of the aforesaid parties in rejecting the applications for substitution after setting aside the abatement. Stop. If the plaintiffs are now permitted to bring on record the legal representatives of the deceased persons on the face of such rejection in this suit, it will not be a proper or fair exercise of the jurisdiction, but an exercise of jurisdiction with material irregularity on the part of the court to allow such application in exercise of its power, either under Section 151 of the Civil Procedure Code or under Order 1, Rule 10 of the Civil Procedure Code. Further, there may be serious questions of limitation involved in respect of the claims for declaration as made in the suit. Stop. I may accordingly of the opinion that in such circumstances once the application for substitution after setting aside abatement caused by the deaths of some parties in a suit is rejected on merits, the plaintiff will not be permitted to circumvent the position caused by operation of law to add them as parties by invoking the aid of Order 1 Rule 10 of the Civil Procedure Code or of Section 151 of the Code. Stop.